Adjournment request, if any, from item number 1 to 7. From item number 8 to 17. From item number 18 to 31.
Lordship, I beg to mention item number 20, Your Lordship, with the consent of the other side, Your Lordship. You need 2 weeks' time to file a affidavit, Your Lordship.
What is it about?
About regarding the post of principal, Your Lordship, in an amalgamated school, Your Lordship.
Rule 28 you have challenged.
Yes, Your Lordship. Obliged, Lordship.
Item number 32 to 35.
Some development to item 35. We have filed review petition.
You want to file review petition?
We have already filed review petition in Honorable Single Judge. So they have served notice. So it may be listed after 3 weeks.
And that notices have been issued review.
Yeah,
Then withdraw it.
You can't maintain both.
Withdraw it. If you have already filed a review petition, withdraw it. Then file if required so.
My senior have instructed me. Senior have instructed me.
Call your senior.
It is in late.
Okay, call them. Whenever the number comes. You can't maintain both the.
Any other request?
Lordship, I beg to mention on item for the listing filed yesterday, on Monday, the review petition of a writ appeal.
Review petition of?
Writ appeal, dispose of writ appeal in any technical matter. On Monday,
For this bench only?
this bench, it was passed by Mr. Justice Mehta.
Now you have filed review petition.
Something has occurred, some issues have cropped up newly. Monday, okay.
Daily list for orders item 1.
Your for? Item number 1. You have not filed this amended cost title.
Lordship, my senior is out of station. In the pass of item.
In these matters, at least you seek instructions. These are the order matters. Nothing, no effective order is going to be passed. As per the office report, amended cost title has not been filed till date. Non-consent for the petition is granted, appellant is granted a week's time to do the needful. Just after a week.
Item 2.
Fresh notice has not been served.
Lordship, we have taken step, Lordship. We have taken step, Lordship.
Await return of notice of respondent number 1 for 3 more weeks.
Obliged, Lordship.
Item 3.
Your Lordship, in we have filed the affidavit in reply today itself, Lordship. Let the matter be fixed after 2 weeks.
Non-counsel,
P board, Lordship.
non-counsel for the applicant has submitted that affidavit on behalf of the applicant has been filed today. It's office to check, and if the same is filed, office to place the same on record. Just after 2 weeks.
Obliged.
Item 4.
Six, 8, and 14 has not been served. 6, 8, and 14. 6, 8, 14, and 18. Yes. 12.
Madam, for the department, Panchayat.
Await return of notices of respondent number 6, 8, 14, and 18 for 3 more weeks, 4 more weeks.
Item 5.
Office note 29/7/2024.
Await return of notice of respondent number one. Notices have not been returned till date.
Yes, Lord, the ID card has not been returned.
Await return of notices of respondent number one for 4 more weeks.
Item 6.
Like, here service is complete of the, as per number one.
Lordship, I'm for the respondent number one. In this case, we need to get the copies of the case.
Copies of what? Petition or application?
I has been allowed, appeal was numbered and.
I has already been allowed. Can लिखिए. Respond, Mr. So put in appearance on behalf of the respondent number one. Services report complete. Identical matters have already been admitted.
Yes, yes.
Identical matters have already been admitted. Nikhil and counsel for the appellant has submitted that various appeals challenging the impugned judgment passed by the learned single judge has already been admitted by this court. Full stop. Hence, admit no need to issue notice.
22 for lordship is admitted.
22,
Lordship is admitted this appeal on.
Acha, already admitted.
Yes, 22.
The appeal is already admitted. While the order dated 20th of February 2024,
22nd of April.
while the order dated 22nd of February 2024. Hence, the matter will listed in due course along with writ appeal number 50/2024.
Yes.
Item 7.
Respondent number has not been served.
My lord, we have taken.
Return unserved.
Fine.
As per the office report, notice is issued to the respondent number one. Return unserved. And it consent for the appellant is directed to take fresh steps for service of notice upon the respondent number one within a period of 1 week on taking such steps that notices be issued to the respondent number one returnable 6 weeks thereafter.
Interim order.
Interim order, if any, to continue till next day. Okay.
Item 8.
Notice upon the respondent number has not been served.
We are taking state for.
Await, we have already awaited.
Hmm. They are taking state for 27/6.
Await, we have already awaited for 4 more weeks. Take fresh steps
Again,
again, naturally.
we have taken state for twice, 2 occasions you have taken. 2 occasions.
Which way? Until the beginning. As per the office report, notice is issued to the respondent number one has not been received either answered. Has not been received either answered or served. Let the matter be listed before the Lauzima court for passing necessary orders
And we reject.
after a week.
Item 9.
Await return of notice of respondent number, but 3 more weeks.
Item 10.
Respondent number 5.
Lordship,
You're
I'm appearing on behalf of respondent number 5.
5. Okay.
Lordship, we would like to file an objection to the condonation of the litigation.
How many days delay is there?
31 days.
31 days. What objection?
My lord,
Precisely, what is your objection?
Lordship, they have stated some
Condone the delay.
31 days only.
Yeah,
31 days only.
we are condoning the delay.
Oh,
Okay. Mr. So and so put in appearance on behalf of the respondent number 5. Service is therefore, service upon all the respondents is therefore complete. Yes, IA is filed on behalf of the applicant with the prayer to condone the delay of 31 days in filing the connected appeal. Full stop. Having heard the learned concept of the parties and after going through the contents of the IA, we deem it appropriate to condone the said delay. Hence, the IA is allowed. The delay of 31 days is condoned. Registry is directed to list to register the connected appeal and list before this court for admission after 2 weeks.
Item 11.
Yes,
Lordship, we have no objection.
we are appearing for
Fishery Department.
fishery department only but other respondents are also there.
Number 5 is there.
Respondent number 4 and 5.
And for 1 and 2.
So the respondent number 4 and 5, the notices have to be issued to the respondent number 4 and 5. Okay. IA is filed with this IA is preferred on behalf of the applicants with the prayer to condone the delay of 31 days. Ms. Arbora and so and so are appearing on behalf of the respondent number 1 to 4, 1 to 3. Let notices be issued to the respondent number 4 and 5. Registered AD returnable 3 weeks,
All right.
4 weeks.
Item 12.
I am for condoning the delay, my
400.
416 days, my lord.
What is the reason?
My lord, the reason is that it was, first thing, it was not intentional, it is beyond its control, my lord.
How?
My lord, on 30/3/2023, the order, judgment and order was passed, therefore, he approached, I have narrated it on para 2, my lord, as page 3, my lord, the whole
Yes.
incident.
Inform
He-
about the said judgment and instructed him to come to their chamber. Chamber after due vacation, there he came to know judgment and order dated. Respondent office. Respondent office.
Because it was direct.
Was the order of
My lord,
order under challenge?
my lord, we get the operative part in page 105, basically, the departmental proceeding was converted to under rule 21.
Pension has been withheld.
Yes, my lord. The whole pension has been withheld and whole TCRD has been withheld and the pension has been limited to 50%. And it was the departmental proceeding was initiated and calculated before retirement. And therefore, learned single judge has converted it to under Rule 21 A. That cannot be done, my lord, because this is the governor who exercises the power, my lord. Under Rule 21.
Para 22 of the judgment.
Yes,
Lordship, in the continuation petition, may record my objection and pass the order.
the matter on the consideration of the IA number so and so with the player to control the delay of 450 days. So the applicant has explained the reason for delay in filing the connected appeal in para number 2, 3, 4, 2, 3 and 4 of the application. Mr. Dina, counsel appearing for the respondent,
1, 2, and 4.
1, 2 and 4 as opposed. Appearing on behalf of all the respondents is opposed the application for condonation of delay. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 416 days in filing the connected appeal. Hence, the IA is allowed. Delay of 416 days condoned. Registry is directed to register the connected appeal and list before this court after 3 weeks for admission.
Item 13.
Fifteen days delay.
Lordship.
Yes,
Delay, I'm not objecting.
you are appearing for all the respondents.
Yes, Lordship.
The matter comes upon for consideration of the ISO and so on, so 16 days वही order कर दे.
Okay.
Now,
Item 14.
you have to furnish the immediate first title,
Yes, my lord.
then
My lord, the notice of an exponent number 1 has been returned since they changed their address. So my lord, we will be allowed to take fresh steps.
Lauzima court has already ordered.
Yes. And
The learned counsel for the petitioner prays a week's time to comply with directions issued by the Lauzima court on 25/7/2024. Just after a week.
For admission, item 15.
This one also. In this case, I'm for the respondent number 1. So we didn't we didn't receive the copy of the text. W.
That is again the same matter.
Same method.
The appeals have already been admitted. Okay, then counsel for the appellant has submitted that this honorable court in identical appeals has already this already court this court has already admitted the identical appeals. To stop learned counsel for the appellant is not in position to dispute the setback. The respondent is not able to dispute the setback. In such circumstances, the matter is admitted, no need to issue notice, list along with writ appeal number 50 of 2024.
Give her a copy.
Yes, sir.
Item 16.
My lord, eventually, when the learned single judge remanded the matter, learned single judge has directed that consideration should be based on a select list, which was earlier interfered by this honorable court. That's the problem.
16 to 2019.
Yes. 16 to 2019 was interfered by this court, my lord, on the, at page 673. Para 10. Accordingly, the present repetition is disposed of by directing the respondent authorities and state selection board to examine the claim of the petitioner and verify the same. And after making necessary verification, if it is found that petitioner had requisite 17 years of teaching experience, clubbing together his experience in the high school and higher secondary school in terms of the clarification made by this court in so and so, recommendation made by the respondent number 4 dated 16 to 19 would be liable to be set aside and necessary direction be issued for reconsideration of the claim of the petitioner. So based on this 16 to 19, which was, my lord, interfered with by making me eligible for selection, because in the earlier round, I was not even considered on the ground that I do not have the experience. So my lord, now the single judge that impugn order at page number, last page of the paper book, my lord, paragraph 10. And my lord, the earlier, I was not in the zone, so I was not considered. Now again, the respondent number 3 alone will be, 7 would alone be considered. Because in that select list, 16 to 19, my name does not even appear. On the contrary, the learned single judge in the judgment says both the cases should be considered.
Returnable, issue notice to the respondents. You are appearing for
Department of Schools, your lordship.
which respondents?
Respondent number 1, your lordship, 120, your lordship.
Ms. So is put in a.
Four is also there.
You are for 1 to 6. All
1 to 6, yes.
Oh, the same authorities, inspector of school,
Private respondent,
No.
secondary education.
Well, perhaps 6 may not appear. 6, I think, notice.
School selection committee, yeah.
5.
School.
Inspector.
Issue notice, learned
Respondent
council
number
so
5.
is directed to accept notice on behalf of the respondent number 1 to 5.
Subject.
Let notices be issued to the respondent number 1 and 7. In the meantime, 6 and 7, in the meantime, the direction given by the learned single judge of completing the process for selection of principal of Hawazar Higher Secondary School as per the recommendations of the state selection board dated 16 to 2019 shall remain state.
Item 17.
Returnable 6. Order. Same order.
Just a minute. Where is the single judge's order here? There is single judge's order also earlier.
Yes, Lordship.
Where is that order?
Lordship, at page 115, Lordship.
Are there orders authored by me as single bench?
No, Lordship. It was the first round of litigation. This was passed by Honorable Justice K.R. Sir
But some orders have
Yes,
been authored
Lordship.
by me.
in the month of December 2000.
Same order.
19.
19 also. 17 and 19 same order.
Highly obliged.
Item 18.
There are two appeals which is pending before the Sound Court. So may I believe that this particular also can be tagged with that case?
Same order
Yes,
or?
yes. What has happened, my lord?
No,
Those two appeals which are pending before the Sound Court. That was passed by one of the original legal heirs of original Patadar has come up before the court by a registration 300.
which the learned single judge has taken note of.
Yes, that's what, my lord. But in that, when we were the tenant, occupancy tenant. So what we have done in person in 2023, a public notice was issued for evicting us. We came up before by filing a writ petition before the learned single judge, saying that we should be protected under the Assam Temporary Settlement Tenancy Act. Some protection order was passed. Independent affidavit was filed. And in the affidavit, the government has taken a stand that already a writ petition has been filed. Subject matter is where you are occupying the land. So we filed an appeal taking leave of the court, condonation that was condoned, and that writ appeal, my lord, was tagged with the original legal of Patadar where correction records of right.
This
Very clear.
appeal is against the order dated 17/1/2023, passed in writ petition number 3003/22.
This is number one. Secondly, because we were not made a party, we were affected by that, so we took leave of the court. And accordingly, leave was granted. But in the meantime,
What is the number?
number is, the one is writ appeal 43 of 2024 where we filed, that's pending. And another writ appeal is, it's 388 of 2020.
Okay. At the request of the concept of the appellant, this list this appeal along with writ appeal number 43/2024
And 388 of 2023.
388 2023. After 2 weeks.
And the clear.
God bless.
Item 21.
In this case, I have challenged the judgment and order passed by the learned cat lordship. In this case, lordship, similar case lordship, but petitioners are different. It honorable court has issued notice.
Issue notice returnable 4 weeks. Petitioner to take steps for petitioners to take steps for service upon the respondent through registered post ID. Steps be taken within 1 week. List along with writ appeal, writ petition number 3598 of 2024.
Item 22 and 23.
May I please?
It has to be go before the single judge.
My lord, it required to be single judge.
This court by the order dated 21/6/2024 has already noticed that essentially the petitioners are aggrieved with the inaction on the part of the respondents in their failure to include the names of the petitioners in the DISC code prior to 2009, and not so much by the insertion of clause ZA,
2ZA.
2ZA, which is challenged under this writ petition. So in view of the said observations made by this court on 21/6/2024, we are of the view that matter is required to be considered by a single judge. Hence, registry is directed to list this writ petition before the appropriate bench.
These, there are two.
Both.
Item 24.
Passover,
Proportionality भी कुछ है।
Passover for the time being or today? Next round, second round.
Item 25.
On 6/5/2024, we have
My lord, my lord will peruse the order dated 6/5/24. My lord, fourth paragraph, my lord.
yes,
Pursuant to that, my lord, she has appeared, my lord.
what
She-
happened?
The writ appellant, my lord, has appeared, and she told that she doesn't have that certificate in writing, my lord.
Which certificate?
That certificate, my lord, has 29/9/23, a certificate issued by Bodo Sahitya Sabha, my lord. That is reflected in the order of my lords.
Yes.
That
Board of
certificate,
Sahitya Sabha dated 29/9/2023, certifying the applicant, appellant writ petitioner as scheduled caste, tribe plains. What happened? She appeared before that.
she appeared, my lord.
Other document, land document, but I print them to consider my land document, but my scheduled tribe status will be different.
My lord,
I the definition, my lord, before the authority on 10/5/2024, along with the court order, honorable court order.
my lord, second page, second last paragraph.
Yes,
It starts from further, it may be mentioned. Further, it may mention that the certificate of Bodo Sahitya Sabha is not available with me. That is, my lord, she told the committee. So, my lord, again, verbally, we have given her some time that you go and look for it if you have come back. Again, we have, there is another single sheet, my lord. We have again informed her to come back to the committee and, my lord, produce the certificate, my lord. My lord, we are going by the direction of this honorable division bench, my lord.
but where is the question of now issuing another notice when she already said that I don't have any such certificate?
My lord, still, my lord, we tried, my lord. It's a,
Take a decision on the basis of the land documents.
my lord, my lord, will take, my lord. My lord, we gave her a chance, my lord, at least, that if she has anything, she can come back. So now,
In her application, she has said, therefore, I want to reply that on the land documents of my grandparents, I may be allowed to place same before the, before to prove my status as SC plain Borokachari.
My lord,
Consider that those documents are new.
Mr. Sarania, to get the benefit as a STP candidate, every candidate has to hold a certificate issued by the competent authority. That is the law,
Right.
correct? The petitioner wants admission in the medical course as a STP candidate, right?
Right.
But she doesn't have a STP certificate.
I have, till now.
Where is the
My
certificate?
only thing is that when I have a STP certificate, when there counseling is my lot going on, then I have to again identify the SDO civil, that I belong to that community. They did not.
Where is your certificate?
I have NX minor, that is there minor. I have NX, it will be issued 2011. Only thing is that they did not identify me.
And
Because
that
they need
certificate, that certificate has been cancelled.
cancelled, my lord.
That's why you approach the court.
minor.
Hence, that certificate was cancelled.
Charge was not cancelled, minor.
That was-
Denying the admission
That
for
was dealt in
getting
the writ petition, my
certificate
lord.
from the-
In page number 25, the writ petition order starts, my lord.
Yes,
That was already dealt, my lord. And only saving thing is that Bodo Sahitya Sabha certificate, my lord, she said that she has one. That is why the honorable single judge,
Where is the certificate?
No, my lord, when he is on that day in the pass of learned single just asked me to bring a certificate photo site Soka. Then my client call up, they give a copy, WhatsApp copy, that has been produced. Then it has been issued by the secretary of the photo site Soka. Thereafter, when controversy raised in the court, the secretary denied that, oh, I cannot issue without the approval of the committee or the president. They have withdrawn. So I do not have the original copy, only the WhatsApp copy that I have produced in the court. The court directed me to produce the same. On the same day issues, but that I have. do not
my
have
lord
the
will find in page number 35.
Mr. Sarania, these are matters, if you have a certificate, you will be entitled to reservation. If you don't have, you can't. As
I have
simple as
mine.
that. Where is it?
Only thing is that they are not going to. At 56 of my lord. 56 of the EDP. My lord, page 56, my lord.
Let it be done.
My son,
page
56.
56.
Issued on my lord 2013.
Rejection order. Rejection order, no? পুলিশে তো এই স্কুলে যেতে নাই পুলিশ না তার সাথে ফটো দেওয়া হলো না এই ফটো দেওয়া হলো তারপরে ফটো
On 6/5/2024. This court,
And that rejection order has been not provided to us. Thus I come to know from that letter field.
that
will ask them to supply them. Rejection order is still they have not rejected your application or whatever it may be.
My
They
lord,
have simply said,
that was produced before the honorable single judge, my lord. And thereafter this in the writ petition, my lord, that order was
No.
passed.
he is, I think so, referring to this fresh order. Fresh order, they have not passed till date.
Mild, not mild.
Not passed, my lord. We haven't passed.
This court by the order dated 6/5/2024 directed the appellant to approach the state level scrutiny committee along with the certificate of General Secretary Board of Sahitya Sabha dated 29/9/2023. Within a period of 2 weeks within a period of 2 weeks, it was further directed that the state level scrutiny committee shall conduct a thorough inquiry as per law laid down by the Honorable Supreme Court in Kumari Madhavi Patel versus Additional Commissioner Tribal Development and others reported in 1994, 6 SCC 241, and thereafter pass a reasoned order within a period of 2 months. Stop. And in concept of the respondent has submitted that the applicant pursuant to the order dated 9/5/6/2024, the respondent has submitted a application before the state level scrutiny committee on 10/5/2024, wherein she has stated that the certificate of Moro Sahitya Sabha, on the basis of which this court has passed order dated 6/5/2024, is not available with her. Stop. And available, she has further claimed that her entitlement for status of STP Bodo Kachari, ST in bracket P, Bodo Kachari, be decided on the basis of the land documents submitted, land documents belonging to her grandparents. Full stop. Learned consent for the respondent has submitted that while order dated 29th of May 2024, the respondent was again granted a time to produce the said certificate issued by the Boro Sahitya Sabha. It stops. But Sahitya Sabha, but till date, the respondent has not produced the said certificate. Which be that as it may, we direct the state level scrutiny committee to consider and decide the claim of the respondent on the basis of the documents, on the basis of which she is claiming the status of STP B Bodo Kachari community and pass a order within a period of 1 month. It is made clear that we are not making any observation on the claim,
Merit.
on the merit of the case. List after 6 weeks. Within a period of, we'll dispose it off with the direction that dispose it of whatever her claim. And if
We'll inform.
you are free to challenge the same if you are agreed by that.
time may not be my lord, 1 month, maybe 15 days. my lord.
1 month, you need some more time.
No, within 15 days, my lord.
No, it's okay. 1 month and 15 days, one and the same. Within a
Because
period of
if
4
I
weeks.
succeed, my lord, then I'll get a seat in the medical.
Let us see, within a period of 4 weeks from today, full stop. We made it clear that we are not making any observation on the merits of the case. We are not expressing any our opinion on the merits of the case. Full stop. With these observations, the writ appeal is disposed of. Needless to say that if the respondent is aggrieved by the appellant is sorry. Everywhere appellant is aggrieved by the decision of the state level scrutiny committee. She is free to avail appropriate remedy available to her under the law.
Deeply obliged, my lord.
Timeline may be my lord, 15 days.
4 weeks, we have already granted time.
Item 26.
I have 4 weeks time to file my affidavit.
Affidavit.
My-
I think we have already granted you time. The concept of the respondent pays for and granted 4 weeks time to file counsel to the writ petition. 6 weeks. Yeah, 4 weeks.
Interim order is there?
Interim order is there.
Is
They are
there?
interim.
He doesn't know. He has an interim order in his favor.
Interim order is I need to continue till next week.
Is there interim order? No, यहाँ पे है next year.
Till next week.
Mr. Chakraborty, you don't know you have an interim order. You are saying no.
Item 27.
In their affidavit, my lord, they said that more than 60% work was already completed. But we have distributed,
50%.
yeah,
50%.
by showing the uploaded photographs as well as the complaint petition. That's not only, so far the first 2 days concerned, only 1.5 kilometers. Only 1.5 kilometers. Half kilometers. And second road, only 8 kilometers. Our road,
Status report.
So overall, 50% work on all the roads.
Four, Lordship, there are four.
They have specified that this first road up to 50%.
can we see the all photographs? It was in the month of May.
Photographs, how can we? Oh, what do you want to say? They have said in their affidavit that so much work is already complete and the work is going on. With a further assertion that they will not disperse the amount for the work which has not been completed. Work is started. Your essential grievance was that the work has not even been started.
No, our grievance was that it is a time bound project. And a particular scheme, chief minister in the scheme, and they remain totally be responsible even to start the contract. What construction?
Once the
And
contract,
when you mock the petition, now they have come with a positive stand on their part, saying
Yes.
that 50% or 60% work was completed. But so far as our assessment is concerned, on the basis of field verification we have made, and on the basis of a photograph which was obtained in July 2027, 24. 1st July. And what?
as per your own assessment or whatever it may be, what you are some technical person? You are a technical person or what?
My lord, assessment in the sense, my lord, the condition of the road. Can you see the photograph, my lord? Everything will be clear. Now, the basis of this photograph, whether one can come to the conclusion that, my lord, any road was at all constructed. Therefore, my lord, what we, my lord, initially pray, that they have an inquiry.
But I would like to pray that, Lord, I will take instruction on whatever photograph they have taken. And Lord, I will also take the up-to-date instructions. Lordship may give us 2 weeks time.
For what?
Lord, the up-to-date progress of the work that I will place after 2 weeks. And the photographs, whatever they have given it here, I'll take instruction on that also.
Entire project work was explained, madam.
The affidavit is the latest year, affidavit you have filed on 29th.
Yes, Lord, we have filed. We have
Now
filed the
what-
affidavit.
What?
On 7th of July, my Lord, in the month of July, we have filed.
Concept of the.
Yeah.
Respondent has submitted that the construction of the construction of the roads for which the petitioners have raised grievance has already been started. And in all, around 50% of construction of all the 4 roads concerned has already been completed. Stop. He raised some time to submit the fresh factual report regarding the construction of the roads in question. Time period for is granted, list after 6 weeks. On that day, Mr. Dina, counsel appearing for the respondent may furnish the latest factual report.
Lordship. Item 28.
Excellent, excellent.
মোৰো instruction আহিছে মই পাইছো। একোৱে চব কাম হৈ গৈছে এনেই। But it is work in progress. আৰু যদি এইটো temporary report 3খন আছে আমাৰ লগত। তাৰ যদি এইটো চোৱা তুমি RTA যিটো আমি দিছো তাতে ক'ত কোম্পানী এনেই কেছ পাই দেখিলে গম পাই।
Item 28.
My lord, I've just received instructions, my lord. I seek 1 week time to file affidavit, my lord, because I would like to controvert his statement. None of his statements have any ground to sustain, my lord.
My lord, we have also received the instruction on behalf of the Superintendent of Police Johar, as well, my lord, anti-corruption and vigilance. My lord, inquiry has been conducted, report has been furnished. We may place it, my lord, within 2 to 3 days by way of affidavit.
Okay, Mr. So-and-so for so-and-so department takes some time to file counter to the PAL petition. Time frame for is granted. Let's confer.
Item 29.
Yes, Lordship, paper publication was made. On the side.
Service of notice upon. At admission stage. Final disposal. Final disposal at admission. Final disposal we can.
Item 30.
बहुत बड़ी बात है। Yes.
This PIL pertains to the growing menace of fake doctors in the state. So your lordships have directed them to file.
Health department,
They file an affidavit.
they
They
filed.
filed an affidavit annexing there with a report. And the report discloses that the ball has just been set rolling. But there is a lot that is
Report,
required to be done.
what suggested?
They have set up a mechanism for inspection. And that process, in fact, just to summarize, I prepared a small chart. Your lordships may have a look.
The affidavit was filed on when?
This was filed about a week back,
Vice.
22nd.
Yes.
If your lordships will kindly turn to annexure A at page 239, they have given a summary of the steps taken.
Action taken in respect of career.
They have started the process of inspecting the hospitals and the other establishment. Page 239, district wise, they have given a chart. For instance, if your lordship takes up the one at serial number 1, Kamrup Metro,
Yes.
they are yet to set up a dedicated helpline number. Then the total number of establishments are hospitals, 64 numbers, and laboratories, 53. And they have inspected only 10 out of them. So the process has just about started. Except 2 districts. If your lordship will kindly turn to page 243. There are only 2 districts at serial number 28 and 30, Nalbari and Sonitpur, where the process of inspection has been completed. In none of the other districts, the inspections are
When
complete.
they have started it,
They've started the process.
started when?
Date has not been. And they have. If your lordship kindly turns to page 241, the inspection at Karimganj resulted in just to bring one thing to your lordship's notice.
Yes.
If your lordships will kindly turn to page 241. Your lordships will find that in Karimganj, this process of inspection has resulted in identification of 18 numbers of fake documents.
That is the reality. The reality. क्या करें? So Chaudhary, the thing is that the people are also approaching them.
Because people are not aware. That is why we
But,
in Orissa,
So Chaudhary, why only talk of fake doctors? There are fake people in almost every profession. What to do?
in the legal fraternity, I am aware
We
of.
are not naming anyone.
At least one was identified in our fraternity sometime. Unfortunately, from my state.
You are not planning to move a PIL for the legal profession? No. Similar relief?
We do not have very specific statistics. If we come across, we certainly can.
this PIL petition is filed by the petitioner raising a serious question, a serious problem regarding the wax operating in the state of Assam. So pursuant to the direction given by this court from time to time, the respondents have submitted has filed an affidavit in opposition where the measures initiated by the state government to curb the menace of quakes in the state of Assam to stop. In the affidavit in opposition, action taken report is also submitted, full stop. After going through the said action taken report, prima facie we are of the view that despite establishment of, what is the name of this unit?
Anti-quackery.
What's the name?
They are calling it anti-quackery units.
Anti-quackery units in each of the district of the state of Assam. Not much progress is achieved in most of the district of state of Assam. Full stop. We are of the view that the anti-quackery units are required to take effective steps to identify the quakes and thereafter to initiate action against them. Full stop. What do you want? What do you want to say?
We will adhere to whatever lordship says. Other than that, they have detected and the chart we have placed in every district.
The
Your lordship,
council
have it up to
appearing
2
for the-
months.
Yes.
council appearing for the health department.
Yes, madam.
I submitted that the anti-quackery units will now take effective steps expeditiously to curb the curb the menace of quacks. He placed some time to furnish the latest factual report. Time frame for the list after 8 weeks. In the meantime, you get the,
Yes,
in all the districts, you.
lordship. I will. Oblige, madam.
Pass over matter 24.
Yes.
One order dated 13/7/2017 has been executed. 13/7/2017. Is that page number 160 of my appeal letter. The relevant portion is at page number 163.
163. Yes.
Not with the entire judgment has been given only on the basis that the bank has not caused with any pecuniary loss. And whereas the writ petitioner has been exceed his instructions, and it has been specific instructions has been given that he should not lend any money to the borrower. Besides that, the money has been lent. It has
To the borrowers.
Yes.
Why?
Your lordship, that there were some implications, so that the power has been curtailed at page number 53 of my writ application. 54 is the last 3 lines. You are instructed not to utilize your lending power for any loan except for loan against our bank time deposit. This is a specific instruction and it has not been disputed. Even in the reply, it was mentioned as that he was under the impression that is at page number 74, the written statement or the defense statement, thereby in 1 number para, reply to the charge 1.
Yeah.
And in the third line, it has been started from waiver your lordship. However, undersigned had under the impression that the renewal and enhancement in the KCC loan limit where the borrower had repaid the earlier due is not a fresh.
So, where you're reading?
Your lordship is number 74.
74.
And in para 1, that is starting from charge number 1.
Yeah, I have submitted, I have never disobeyed.
Line number 3.
Higher authority center, however, the undersigned had under impression that renewal and enhancement of the loan limit where the borrower had prepaid the other due is not a fresh sanction. And as such, not reported to the control return, but in the above action by interpreted by the Nigerian Procedural Court.
So the bank has not suffered any loss.
Yes, your lordship, there is no sufferance of any loss. But your lordship, he has exceeded his power and he has given a loan. That has been
Under the impression that in KCC loans, it's a not a fresh loan, it has to be renewed only. What's
Yes.
wrong?
No, your lordship, but his power has not been given to him, that he should not lend any money to the borrowers because they are the delinquents. All because of the 173 cases only, your lordship, not one and
So there are other major penalties under dismissal, including compulsory retirement and all this.
there are others.
So if there is no pecuniary loss, why go for dismissal? There are other
No, your
penalties.
lordship, there are other charges also. Altogether, the 8
Other
charges.
charges, what other charges are? Where is the charges?
Yes, sir. That is at page number 64, your lordship. 66 is the specific one, your lordship, that is from charge number 1. That is the, as I have stated, your lordship, that Mr. Sri Sharma
Yes. Charges are
at page number 66. sir.
66. Charge sheet.
2 charges has been issued,
Who charge?
containing 4 charges. That is charge number 1, where he has not followed and disobeyed the instructions of the higher authority. And it has created an serious financial anomalies in sanctioning and disbursing of loan in 173 KCC loans, your lordship.
No, just
Yes,
page, you are reading a page
page 66, your lordship.
66. Rabin Chandra Sharma,
Yes,
presently doing the bank with effect from under the regional level committed the following loss. Shri Sharma is branch manager violated this with instructions. Okay, fine. Shri Sharma committed serious financial and sanctioning and dispersing 173 KCC accounts. Branch of geopardying the pecuniary interest when his lending power was seized. Branch manager ordered to conceal and mislead financial transfer account did not report his higher authority about such loans to periodical control returns acted. This is in relation to the same KCC loans.
yes, your lordship. These are the financial anomalies, your lordship. And he has never informed in the periodical returns of monthly returns to the bank.
But he was under impression that this renewal
Your Lordship,
That
when
may
there is
be a
a
bona fide.
specific instructions is there, it cannot create any impression. It is not a
Where are the penalties under the bank's standing instruction?
Bank's standing instructions.
not restricted.
No, complete all the.
My lord, that has been quoted, man. Kindly, your lordship will find. I'm sorry to interrupt, man. Page 44, my lord. Page 44 of the writ appeal. I am sorry to intervene. Page 44, penalty. Page 43, it starts from 43, my lord.
Yeah.
As per the regulations, my lord. Penalties. Kindly, your lordship got it, my lord.
Yes.
The following penalties which may be imposed on an officer, employee for an act of misconduct or good and sufficient reason. The minor penalty censure, withholding the increment, withholding the promotion, recovery of pay and suspension charge, reduction of lower stage of the time scale, and major penalties. Kindly, your lordship. Save as provided for E and the above reduction to a lower stage in the time scale for a specified period, which further decision as to whether or not the officer which earn increments paid during the period of such reduction, and whether the expiry of such period of reduction will not have the effect corresponding the future increments. Reduction to a lower rank or post, compulsory retirement, removal of service shall not be disqualified for future employment. Dismissal is a larger one. Dismissal which shall ordinarily be disqualified patient for future employment. This has been given to me. And my lord, kindly, the honorable single judge has remanded the matter to the authority to take appropriate decision in a proportionate.
He is at the moment out of service.
Yes, since my lord, since 2007. $17 my lord. And honorable single judge have just remanded matter to the bank, my lord. The
What
authority.
is the penalty order?
My lord,
Penalty order.
penalty order, yes. Dismissal order, yes, I'll. Dismissal, page 95, my lord. Annexure.
ग्वादर सात का है. So disqualification means his retirement dues will be forfeited.
Everything.
That's disproportionate. That's personally my opinion. What my lord. He in any case is not going to get employment now. He must have exceeded the age of re-employment. You have not suffered any loss. Why you want to make him suffer loss?
Your Lordship, but the case is proved beyond doubt. There is nothing finding in the judgment.
But how you have dealt with this explanation? Which he has said that he was under the impression that those KCC loans are not fresh loans and their renewal is there. How you dealt
He has
with
not
that?
denied that he has not received the letter or instruction from the higher authority.
He has explained it.
Even a simple
Rightly
plea,
or wrongly, he has explained it.
or if someone, they picked up someone's goods and tell them that I think that it is my goods, then your Lordship, the entire scenario will be changed.
Fine.
Because it's a public money, he's dealing with the public.
Looking to the fact that the respondent is out of employment since 2007. We, with the consent of the parties, the matter is heard. Finally, stop arguments heard. Order reserved.
Supplementary list, item 36.
I think so. The pleadings are complete for where is the question of return notes?
Very limited.
Yes.
So Lordship kindly take up an answer 3, page 15. One, this has been issued. One order is issued by the district magistrate. Subdivisional magistrate. Page 15,
50,
1/5.
1/5.
This is with regard to the possession notice, my lord, that was issued under SARFAESI. Now, this order says, my lord, my property will be taken over by the my lord, authority, respond number 2,
Your property which is mortgage.
mortgage. My only prayer in this case, my lord, I need only 15 to 30 days time, my lord.
Ask the bank authorities, they'll provide you the time. We are not,
Only
we have not
today they have provided
handed
time.
you any money.
My lord, either I will pay the whole money or I will evict my property, I'll vacate my property of my own, my lord.
You go and tell the bank authorities.
They are not listening to my.
Oh, we are not supposed to listen because we have not lended you the money. They are the persons who have lended you.
Only 15 days, up to 15th of August, my lord.
On merits or
No,
liberty to approach the DRT.
that will also suffice.
That withdraw this will grant you liberty to approach the DRT.
With 15 days protection. Sir.
Nothing. Sorry. What else?
My lord, on merit, I have nothing to say. My three
On
smooth
merit,
going
we have
children, my
nothing
lord,
to
they will
say,
be
and
ousted,
also,
my lord.
we have nothing to, we are also not inclined to pass an order on merit because there is nothing on merit.
Lord, I am ready to pay. I am ready to pay.
No, ask the bank authorities.
They are not providing me.
They are not
One
providing
single
me.
opportunity.
It's
15
up to
days
them.
time, my lord.
Ultimately, it's public money. It's not a.
If your lordship provides me, my lord, 15 days time, my lord, to approach the DRT.
How much is the amount due?
My lord, according to them, with interest 1 crore 29 lakhs. It's noted. So it's not a case that he did not pay any.
Yes, that is there. Every case is like this. What do you want? Withdraw or on merits?
10 days time, my lord, at least, to approach the DRT.
This writ petition is filed by the appellant challenging the notice, the order dated 11/7/2024 passed by the Office of the District Magistrate, Kamrup Metropolitan District. Whereby the ACS Executive Magistrate Kamrup Metro is deputed to oversee law and order during taking over possession of the following secured assets by the bank authority as per the provisions of SARFAESI Act. Full stop. It appears that the bank has initiated proceedings for realization of the loan amount lended by it to the appellants. And in the said process, the possession of the property mortgage, the property of the petitioner mortgaged with the bank is got to be taken with the aid of the administration. Stop. Having heard the learned counsel for the petitioner and after going through the material available on record, we are of the view that if the appellant, the petitioner is aggrieved by the action initiated by the bank, respondent bank authorities under the SALFACI Act, he has an alternate and efficacious remedy to approach the debt recovery tribunal under section 17 of the Securitization Act. Hence, hence, we don't find any case for interference. The same is hereby dismissed. The petitioner is at liberty to avail appropriate remedy available to him under the SALFACI Act.
That's about 10 days, 90.
You can approach even. uh, Available to him under the SALFACI Act. Full stop. At this stage, the net concept of the petitioner has submitted that if 1 month's time is granted to him, to the petitioner, he will pay the entire amount, entire outstanding amount to the bank. Full stop. We are taking into consideration the submission made by the learned counsel for the petitioner. We granted, we are of the view that the petitioner shall approach with this proposal to the bank authorities. And
Within 3 days.
Within 3 days, and it is expected that if any such proposal is made by the petitioner, the bank authorities shall consider the same objective.
No, pleasure. Much.
For hearing, item 31.
I am for the private respondents in this case.
Who is for the
Previously, Mr. KK Nandi had appeared previously. My lord.
password for the time being? Yeah, he is not a,
I have not seen him, my lord.
for the time being.
Item 32.
There is a scheme.
My lord,
People killed by extremists.
It is
What is the amount payable under the scheme?
My lord, it is rupees 3 lakhs, which has been enhanced, my lord, by notification. Earlier, it was, my lord, at one point of time, it was 50,000. It was increased to rupees 1 lakh, 10 to 2 lakh. Finally, my lord, it has been increased to rupees 3 lakh. There is a notification. And my lord, so many petitions under similar circumstances, my lord, arising out of extremist killing, or my lord, person going missing due to abduction or kidnapping by the extremists. And so many petitions have been filed before this honorable court. And there are so many decisions by this honorable court. However, my lord, the petitioners have been, my lord.
You are not disputing that he has been killed by extremists.
No, my lord, my lord, the fact remains, my lord, that the person, husband of the petitioner, he had become untraceable. And he has, my lord, been abducted, my lord. It is alleged, my lord, that he had been abducted by, my lord, the extremist, my lord. An extremist group, my lord, called DHE, my lord, in the district of West Karbianglo.
That is not disputed.
That is not disputed. Now, here, my lord, there is a scheme, and during the pendency of
You pay him 3 lakhs, no? Then we'll see what other.
that 3 lakhs has already been paid, my lord, during pendency of this debate, my lord. Did he? Yes, my lord, already. Yes, my lord, we are only aggrieved by, my lord, that quantum of damage that has been assessed by the honorable single judge. 10 lakhs, my lord, it is in the wrong.
You are not party before the single judge.
Yes, we are not party, my lord, and we are the revenue and disaster management department is the department which is concerned to provide, my lord, rehabilitation as a grant, my lord, to the person concerned. And so many petitions are filed before this honorable lordship is aware, my lord, that in all cases, my lord, the court directs to pay 3 lakhs. Any judgment? Yes, sir. I'm relying on, my lord, the expert decision, my lord.
So, Mr. Mohanto, if others have received 3 lakhs in similar cases, why should your client get 10 lakhs? What is the legal?
The 3 lakhs has been paid in terms of a policy, which is
Correct.
ex gratia, my lord.
Yes.
Now, what the honorable single judge has decided that she is entitled to 10 lakhs because of the peculiar circumstances and for violation of Article 21, my lord.
What peculiar circumstance?
Peculiar circumstances as in, my lords, after the husband was kidnapped, she was demanded ransom by the group, my lords, and she had paid an amount of 20 lakhs and then informed the police, my lords, about the payment, my lords. And the police at that time, when she went to pay the ransom amount, the police never accompanied the petitioner, my lords.
Ransom amount के लिए
And in any
you
case, my
suppose
lords,
that the police will accompany to pay the ransom amount.
it was informed to the police first. It was informed to the police first, and it was. And my lords, if I may kindly point out, my lords, if I may kindly point out, my lords, the ground taken in the appeal, my lords, that they were never arrayed as a party. If my lord peruses the cause title, the chief secretary has been arrayed as the party, my lords. Now, my lords are aware, my lords, he is the secretary of the cabinet and he is responsible for all departments, my lords. But that cannot be a ground that they were not made a party, my lords. The chief secretary was the party who was the respondent number one. And in any case, my lord, if my lords, they were not arrayed as a party, they ought to have filed a leave for appeal, my lords. That has never been filed. To prefer an appeal before the division bench. There has
Please kindly consider what you are, your assertion of making payment of this paying this 20 lakhs ransom amount, that has not been believed by this court.
My lords,
This has not been believed by this court.
the quantum of amount, yes.
No, the court has in para number 19. Though the fault on the part of the is clearly visible, it can also be observed that there was no active participation by any agency in abducting the petitioner's husband. Though the petitioner has also alleged that the petitioner has paid a sum of rupees 20 lakh towards ransom, unfortunately, there is no corroborating evidence other than the statement made by the petitioner before the authorities. Though the authorities did not examine the issue properly, in the absence of any clinching evidence to reflect that the petitioner has indeed paid rupees 20 lakh to this court cannot consider the same while determining the amount of compensation.
My lords,
However, considering the peculiar circumstances in which the accord revealed by it seems the payment of ransom is totally ruled out.
my lords, my lords, I've been newly engaged, my lord. Give me 1 week's time. I need to prepare, my lord. I'll place certain judgments, my lord. And whether a writ appeal is maintainable at all, my lord, because it was a writ petition criminal, my lord. Whether a writ appeal to the division bench is maintainable.
Petition.
It was a WPC criminal, my lord. The order was passed. Lordship would give me 1 week's time. I'll satisfy on the merits.
You are right. But in a criminal writ petition, how compensation can be directed to be paid? Satisfy us on that also.
My lord.
If a writ appeal is not admissible, somebody, the state is being directed to pay 10 lakh compensation and they will be remediless. Habeas corpus petition strictly is only to have the person
produce the body.
Person. But then the learned single judge is directed compensation. There is a scheme where everybody gets 3 lakhs. Suddenly there is a departure.
Right.
Peculiar facts, the most crucial fact which you are relying upon. The learned single judge has disbelieved this story. Then where is the peculiar fact here?
My lord, so, give me 1 week's time. I've been newly engaged. I'll satisfy on all the points. I'll take note, my lord. I'll satisfy my lord. Try and satisfy my lord.
But only with all respect, one submission, my lord. My lord, the submission has already been made by my learned counterpart that we have not taken leave of this honorable court. In fact, we have taken leave, my lord, higher to second. We have filed a leave application before this honorable court. Since we were not guaranteed.
He is newly engaged. He didn't.
I'm so sorry, my lord. I was not aware, man. That I was not.
Leave has already been granted by this honorable court, my lord.
Yes, there's an.
Leave has already been granted.
I take back my.
And it was the condition precedent imposed by this honorable court that we grant you, we are granting you leave, subject you pay rupees 3 lakhs.
That has been paid, my
We
lord.
have already paid, they have received it.
Lordship may fix it next week, my lord. Give me some time. I'll try and satisfy, my lord.
Tuesday, next Tuesday.
Next Tuesday. I'm deeply obliged.
I'm so glad you.
Item 33.
Okay, Mr. Lord. My lords, we have challenged the impugn order that lordship may kindly see page 174. In our body portion starts, my lord, page 179. My lord, I am giving a story of the case. Story of the case is like this, my lord. On 5/4/2007, on 5/4/2007, the district Karimganj acquired a plot of land measuring 8 biga, 4 kata to Katak under section 6(1) of the Land Acquisition Act 1894 for construction of parking bylays at Pathargandhi in the district of Karimganj on 5/4/2007 and other dates. The lands were handed over to PWD Department on 10/12/2008. An award was passed on 7/5/2017. They say the land was handed over to the PWD. It is disputed matter. Even then, my lord would kindly see they have acquired the land on 5/4/2007 and award was prepared on 7/5/2017. That is, my lord, nearly 13 years later.
May please, your lord. And if you allow to call the standing council for revenue, my lord, they are also party here. Standing council revenue, my.
So
My lord, they are also party. They are the party here, my lord.
call them.
Yes, madam, I may be allowed to call. Yes, ma'am.
Well, may I continue?
Just a minute. Word was passed on which date?
My lord, award was passed on 7/5/2017.
7/5/2017.
Yes. As per section 11A, it is said, my lord, the collector shall make an award under section 11 within a period of 2 years from the date of the publication of the declaration, and if no award is made within that period, the entire proceedings for the acquisition of the land shall lapse.
Where you have raised this ground before the learned single judge?
My lord, these were raised.
Where is that? Show us from the order.
It was said that they were not paid amount, that they were not paid amount.
Show us the
Well,
ground, sir.
Let,
You have raised and not considered.
What is the mean?
You have not challenged the acquisition proceedings as such. On the ground that the award was not passed in within a specified time. You have simply said the the respondent authority to revert back the land to you, which was acquired. This was your case.
Worship can see for a moment, page 180. Not so clearly mentioned, but there are indications. 180.
Para
Para number.
180 of the judgment,
No, read a bit.
writ appeal. Yeah,
Para 3,
180. This is the
Second.
order by the learned single judge. Yes.
para
Para
3,
three.
second part. Pursuant to inquiry under section 5A of the Act 1894, the declaration under section 6(1) was issued declaring that the land measuring 8 figures 9 katas 2 sotak, as specified in the state declaration, was required for public purpose, that is for construction of parking laybys at Pathargandhi, 20 kilometers in Bhojad, Dullabur, part 2, Fargana, Pratapgarh in the district of Karimganj. This declaration under section 6 was made on various dates. The last of such date was 7/5/2007. Thereafter, award was passed in LA case number so-and-so on 7/5/2007, and possession of the land was taken and handed over on 10/2/2008. It is the case of the petitioner, the petitioners were paid 80% of the total amount compensation. However, no possession of the state land acquired was taken. It was further contended that in the meantime, in the year 2013, the government of Assam, by notification numbers in LA case number so-and-so, acquired a plot of land measuring 30 bighas, 10 sotak in Bhoja, Moina, part 1 Fargana, the Fargas in the district of Karimganj for the purpose of construction of Pathargandhi bypass on National Highway 44, and the said construction of the bypass was at a distance of 3-4 kilometers away from the parking levy rise for which the land was acquired in LA customer so. Consequently, as the said land has become useless in view of the construction of the bypass at a distance, the petitioner filed representation before the Deputy Commissioner Karimganj for return of the land so required in LA customer so, and the petitioners were willing to refund the payment of the compensation so received. It is also the case of the petitioner that by virtue of section 101 of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act 2013, in short, the act of 2013, as the lands have been acquired in like customer so on the basis of award dated 7/5/2007 had not been utilized by the authority, the same is required to be returned to the original owners or the owners or their legal heirs, as such the petitioners requested the authorities concerned for return of the said land acquired from them. The authorities did not take into consideration the petitioner's request, and on the other hand, on 18/9/19, the circle officer with the local police equipped with bulldozers, JCB, etc., without issuing prior notice to the petitioner or any other similarly situated landowner, entered the acquired land and demolished the house. So, Lordship, on 18/9/19, they demolished our houses. That means that though they acquired the land in the year 2007, but till at least on the basis of the contents of the judgment, my lord, it appears that on 18/9/2019, by force we were evicted.
It was not your case. This was not your case before the learned single judge. In fact, you have received the compensation without raising any objection, but simply come with that though the land was acquired in the year 2007, but since the work has not been started, therefore, their land be returned back. This is what your case is.
But it is the matter within 5 years, if the land is not taken, then my lord, the entire proceedings becomes lapsed. So that is the mandate.
That is the Supreme Court judgment Constitution bench specifically said that this provision of section 101 can't be made applicable in the cases where the land was acquired in the Act of 1894.
Yes, madam, that is there, but this is pretty applicable on its own merit. That is also here in this case, madam. Lordship may kindly see for a moment, that is there, but Laya single judge had not pointed out the same, but we will point out here, madam. Kindly see page in 185 of the repeat. Section 24 deals with lapse of acquisition. Section 101 deals with the return of unutilized land. Section 101 cannot be said to be applicable to an acquisition made under the Act of 1894. The provision of lapse has to be considered on its own strength and not by virtue of section 101. So, my lord, on its own merit, though that section is not applicable in respect of the lands which were acquired under the Act of 1894, but it is split and on its merit, it is applicable. Now, here they have filed an affidavit. If your lordship kindly see their affidavit, I may say how they have filed the affidavit. Kindly see the affidavit page, my lord, page 190. One nine two.
इनको compensation पूरा मिला है तो कुछ बच गया तो इनके अंदर तो जाते कुछ इनको चाहिए जमीन You point out for me. Mr. Mahmood, please listen to what we are saying little carefully. The ground you are urging today, this was not specifically taken before the learned single judge. So the principle is, if you have not taken a ground before the single judge, then in the appellate stage, this appellate court cannot appreciate that ground. So we are asking you, do you want to go back to the single judge and seek a review on this ground? If you want, we can grant you liberty to withdraw and file a review. Thereafter, if you are aggrieved, you can come back. Otherwise, you can argue and we'll have to pass orders. But we have to go as per the principles of law.
Right.
That you understand. So the principles say that
Lordship may kindly, but
You-
maybe remanded back to the London single.
not remanded.
Remanded.
You will withdraw with liberty to prefer review.
Liberty to file a review petition.
That is up to you, if you want.
Lordship, yes, that is better for me, I think, better for us. Of course, there are also citations of our High Court and the Supreme Court. Then appeal some new grounds may be also raised. There are so many citations also, but I am not on that because I want to get the relief very simply without going into controversy. So Lordship, withdrawing, but liberty may be granted.
You want to withdraw.
And
With
a
liberty.
limit, a timetable may be.
That how can we? say?
Timetable?
Timetable, that's when, if any petition is filed, London single judge shall dispose of the same with it. Because my lord, in matter of
Please,
2007, my lord,
Please,
many persons have already died.
please. It is your request. You want to file a review petition. It is for the judge to decide whatever time it will take, it may take. How can you ask for that, sir? And how can you order that?
Division bench may act to,
No, no, don't withdraw it, argue it.
no, I
Yeah.
am withdrawing.
Then
But I have,
we are not.
now here I am withdrawing because yes, I have also seen that these grounds which are very much logical and legal were not raised. So I am withdrawing and liberty may kindly be granted.
LC case number 2/2002/2003. Where is that? Copy of that? The
Is it-
final order passed in LC case.
Is it LC or LA case? LA, but you have written LC.
LC or LA case 2002/3, where is that final order? LA case number 2/2002/3.
Look, there are three requisitions. Those requisitions were taken up together and by common judgment, the requisitions were disposed of by the London single.
So this appeal arises out of which writ petition?
Three. Because there is a common judgment, we have taken that benefit.
After attempting to argue the matter for quite some time, then counsel for the appellant on instructions as submitted, we want to withdraw this writ appeal with liberty for the appellant to file a review petition before the learned single judge, dismissed with liberty as prayed for. In view of the above, this writ petition is dismissed, the writ appeal is dismissed as withdrawn with liberty to the appellants to file review petition before the learned single judge if law permits to do so.
Item 24.
As per law, in accordance.
In accordance with law, in accordance with law.
Yeah, please. It's a compassionate appointment, my lord, and under single judges, since my it is on the ground that I failed to show there is existing vacancies, my lord. So, my lord, kindly schedule the improved order is the one from 135, my lord. The 11 starts from 138, my lord.
Only in these cases. If we got to close the door completely, I can it's going to discontinue. If we close the door,
When your father died in,
My lord,
your father died in which year?
father died, my lord, on 18/1/2014, my lord.
14.
And I have applied for compensation for 23/2014, my lord, within 1 year, my lord. Thereafter, my lord, this honorable court also direct, in the case number 1724/2020, which is disposed upon 14/2020, that is at page 58, your lordship may get it. There is a specific direction that my candidate, case may not be considered on the ground of vacancy. My lord. Your lordship may kindly peruse at page 68, my lord.
68.
68. Paragraph 6 is the relevant.
Yeah.
What is that? Undertaken by the respondent will be taken from the date of receipt of certificate copy of the and the result thereof. shall be informed
They're considering the submission and directing the respondent to reconsider the gay appointment and the Diana harness scheme by placing the matter before the. Why? Why?
Non-availability of vacancy matter. That was never placed before, that order is never placed, and that was not considered, also not considered by the DLC matters. My lord, may I kindly peruse the DLC on that page 126.
But ultimately, now show us. 10 years have passed
My lord,
when the father of the petitioner has died. Now, what is the financial hardship? Now,
that's true, my lord. But I am
so
writing
then
for,
on this point itself, we are not inclined to it.
that is your procedure.
This writ appeal is filed by the appellant being agreed by the order dated 16/3/2022, passed by the learned single judge in writ petition number 5393/2020. The appellant has approached the writ court under Article 226 of the Constitution of India with a prayer for setting aside and quashing the DLC, the decision of the DLC Barpeta district dated 7/3/2020, whereby the claim of the appellant seeking compassionate appointment, seeking appointment on compassionate ground has been rejected for the reason that no vacancy of class 4 post, of grade 4 post was available to provide appointment to the petitioner, to the appellant on compassionate ground. Stop. The learned single judge has upheld the decision of the DLC while observing that if the 5% vacancies kept separately for providing appointment on compassionate ground are not available, no direction can be issued to appoint the petitioner, to appoint the appellant on compassionate ground. Stop. Having heard the learned counsel for the appellant and after going through the material available on record, we are of the view that the learned, that there is no illegality in the impugned judgment passed by the learned single judge. Para. We are also not inclined to interfere in the matter, taking into consideration the fact that the father of the appellant died in a harness in way back in January 2014. And the January 2014, and as such, 10 years have already passed. And the petitioner, the appellant and his family have able to manage their life without there being employment offered by the state government. Hence, at this stage, no such direction for appointment of the appellant on compassionate appointment of the appellant on compassionate grounds can be issued. With these observations, this writ appeal is disposed of.
Item 25.
Maybe. In this case, my lord, there is last indicated so I have filed one review petition against the order dated my lord 22 to February 2021, passing application 1034 2021. Based on this order, actually the improved actions is the current existence. And yes, because this order is or writ petition was not filed by the one of the petitioner, it is a third party writ petition along with the review. We have to file the application for granting the permission to prefer the review. That the mistake notice is already been issued by the Honorable Single Judge, and notice returnable time forward, and it is likely to be listed for the Single Judge. And in the instance,
One minute. Mr. Pukasta, the order under challenge in this writ appeal is the same order against which you have preferred a review.
No.
Then
Then I prefer the review, my lord, against which the impugn notification has been issued by the Guwahati University in compliance of this order of the another writ petition, my lord. Another writ petition, which has resulted, my lord, the rejection of my candidature.
So the notification under challenge was issued by the university pursuant to the order passed by this court,
It's single bench, my lord.
single bench.
Yes, in another writ petition, where I
But
was,
in one of the case, in one of the case.
where I am not the party.
So what's the illegality in the notification then?
But my lord, in that.
If that is in
notification,
pursuant to the
that
direction
order-
by this court, then what's how you can challenge that until and unless the judgment goes?
Yes, therefore, my lord, we have preferred this third party review, my lord, before the Honorable Single Judge against the order, the original writ petition. That is 22 to 2021, and W.
The learned single judge has dismissed your writ petition on the ground.
This writ petition has been dismissed on the ground that because the original order of the another writ petition that has to be modified, otherwise the instant proceedings cannot be taken into consideration. That with that observation, the Honorable Single Judge in this instant writ petition has. Thereafter, we have preferred the case in appeal. Yeah.
Now, what do you want?
Well, therefore, I'm saying, well, this appeal may taken after some days. my lord.
Some days you withdraw it, and after the decision of the review petition, still something remains, then you can challenge it.
My lord, in this appeal, my lord, interim protection is given with regard to my lord appointment of the concerned post, my lord, not to fill up that concerned post.
Stay order is when the stay order,
It's gonna take, dated 1/8/2020,
1/8,
1/8/2022.
22. ये stay क्या हुआ है? What is this stay?
But if the process goes on, my lord. to the
Any
eviction-
process undertaken by the respective resident shall be subject to further court of this order. That is already, I mean, if they नहीं भी देते हैं, writ petition में interference करते हैं, then they would have done it.
and
Mr. Consul, please. The learned single judge has dismissed your writ petition on the ground that the notifications which you are assailing were passed pursuant to the orders passed by this court in two petitions. Either those orders are reviewed or modified, we don't find any fault with the action of the respondent university issuing those notifications. Since you have already preferred an review petition, though there was an option before you to challenge those orders by way of writ appeal after seeking leave from this court. But since you have already filed a review petition, what's wrong in this judgment? How we can find any fault with the judgment of the learned single judge?
Philip, that has to be
Actually,
reviewed,
that's the position what we
Yes,
have explained.
yes.
Then what remains then?
A review has to be taken first. my
No,
lord.
no, do you take the review, whatever the review, whatever will happen, you, if review petition is dismissed, you can very well challenge that order. If review petition is not dismissed, then you will get the relief or whatever it may be. Nikhil,
Your lordship will indicate kindly that, if the review petition is allowed, my lord, then that depends my cause of action will be again.
कैसे हम- also depends upon, we are simply saying, देखिए, this writ appeal is filed by the appellant being agreed with the order dated 24/6/2022 passed by the learned single judge in writ petition number 4165 69 of 2022. The petitioner before the learned single judge has assailed the validity of the notification dated
2022, my lord.
2/2
2022. 2nd February.
2nd of February 2022. No, the decision of the academic council है ना?
Okay.
Before the writ court, the petitioner has challenged the decision of the academic council of the Guwahati the university dated 2/2/2022, as well as the decision of the Dibrugarh University dated 12/1/2021. Stop. Learned single judges observed that the said decision of the Guwahati University, said decisions of the Guwahati University as well as the Dibrugarh University were taken pursuant to the order passed by this court on 22nd of February 2021 in writ petition number 1034/2021, as well as the order dated 7/11/2020 passed in writ petition number 3642/2021. The learned single judge of the was of the view that the said judgments still holds the field. The above referred judgment still holds the field and has not been reversed or reviewed, and therefore no fault can be found with the decision of the respective universities in passing the impugned orders. Full stop. Learned counsel for the appellant has submitted that he has already preferred a review petition seeking review of the order dated
It is my lord, 22 February 2021, passed in WPC 10.
22/2021, passed in writ petition number 1034/2021. And that review petition is still pending.
Notice is issued in the connected miscase, my lord.
Connected?
Miscase, like interlocutory application, my lord. For third party review, take leave, my lord, to prepare the
But and that still that review petition is still pending consideration before this court. Full stop. In such circumstances, we are of the view that when the appellant has already filed a review petition seeking review of the order dated 22nd of February 2021, passed in writ petition number 1034/2021. No. We find no reason to pending to keep this writ appeal pending. The same is therefore disposed of. However, the petitioner is, the appellant is free to avail appropriate remedy in case the review petition decides for or against him.
After the disposal of the it will be open for the appellant to seek appropriate legal remedy against the impugned order dated after the disposal of the review.
Impugned order dated passed in this petition against the impugned order dated 24/6/2020 after the disposal of the review.
Pass over meter 31.
There is none for the petitioner, it seems.
We'll pass it over for day.
Or can a date be fixed in that case?
Will come the next hearing day. Tuesday. Next hearing day, Tuesday.
6th, yes.
6th.
Like,
None present on behalf of the petitioner. This petition for a hearing on 6th of September. It is the hearing day.